Hello students. Now after understanding the meaning and nature of tort, let us understand the nature of tortious liability. Nature of tortious liability, again, it can be understood from two different perspectives. Philosophical perspective and the element or the content perspective. That also comes under the nature of tortious liability. We know it very well, the general conditions for imposing tortious liability. That is, a wrongful act, legal damage, and legal remedy for the damage caused by the defendant. Before that, let us understand the philosophical perspective. This nature of the tortious liability has been evolved into a debate of whether it is a law of torts or law of torts, and accordingly these two philosophical theories explain the nature of tortious liability in a philosophical perspective. The first theory is law of torts and the another theory is law of tort. Now let us see what is the law of torts theory, T-O-R-T-S, plural. It is also called as a pigeonhole theory as supported by Sir Frederick Pollock. Now this theory, actually that is a law of torts theory, is in the form of a debate of the title of this branch of law of torts or a law of tort. It has been explained by Sir John Salmond. So many times this theory is also known as Salmond's theory. Now according to this theory, the Salmond says that there is only the law of torts and not law of tort. According to this dictum, law of torts, it consists of a number of specific rules prohibiting certain harmful acts. So these are defined specific rules which prohibits defined harmful acts. So for those defined harmful acts only, the law of torts provides for the different principles, and through those different principles, but definite principle, it provides for those specific remedies. Thus, Salmond is saying that there are specific well-defined wrongs, and hence the law of torts, it doesn't deal with a general law of tort but the specific well-defined torts, and hence the Salmond propounds or explains that there is no general law of tort. This further means that there is a list of acts and omission which amount to a wrongful conduct in those certain circumstances, and only those acts and omissions are actionable in a court of law. Thus, according to this theory, only those harms which fall within one of the either of the categories which are defined, that only entitles a person to file a suit. There are specific or defined crimes which we call even as an offenses under Indian Penal Code. Likewise, Salmond is explaining that there are also well-defined civil wrongs under torts which are called as certain specific torts. So, the law of torts provides remedies only for those specific torts or defined torts, and all other wrongs which fall outside the law of torts are not dealt by this branch of law. Thus, law of torts consists of definite number of torts outside which the liability in a tort does not exist. So, on this basis, this theory is a law of torts. Now, if we talk about this theory, no doubt the theory has its advantage that a tort is not dealing only with a one wrong, a particular wrong. But different kinds of the torts are there, as we have earlier seen. Torts relating or to the person or against property, against persons such as assault, battery, uh, or even the proprietary rights such as trespass, or against the right to reputation such as defamation. So these are the specific torts. So no doubt the law of torts, it appears to be correct. But the criticism made or the limitation of this theory is that this theory as propounded by the Sir John Salmond, it does not allow the recognition of new torts with a changing situation, with the changing social circumstances. Thus, this theory of Salmond has been criticized by various writers, various jurists, and on the ground that if this theory is accepted in toto, then the categories of the liability in a tort would put to an end, would be closed, and the courts would be prevented from recognizing any new torts. On the other hand, so these are the various torts, various kinds of the torts which we have discussed. On the other hand, another theory is propounded by Sir Winfield. It is known as Sir Winfield's theory, which is based on general liability principle. The supporter of this theory propounds that it is not a law of torts, but it is a law of tort, which means that this branch of civil law, it deals with all the injuries done to another person unless there is some justification recognized by law. It means that law of tort is not limited, it doesn't define or deal with the limited civil wrongs, that is the torts. What the law of tort is dealing with? So it deals to provide a remedy for a wrongful act. So this is a general liability principle. A person on whom a legal duty is there not to cause a harm to any other person, and if he commits a wrong act which in consequence amounts or causes some injury, it may be of any kind, it may be with respect to a person, it may be with respect to the property, it may be with respect to the violation of any legal right. Sir Winfield thus says that there is a general law of tort, as this liability principle is a general liability principle so as to provide a remedy to a wrong. Thus, this theory deals with the general liability principle in a tort and not definite principles for imposing tortious liability. Now, if we talk about this theory and its merit, the theory thus promotes the recognition of the new torts in comparison with the Salmond's theory, which restricts or it closes the door for the recognition of the new torts. So, from philosophical point of view, it appears that Sir Winfield's theory to be more correct. But practically, we say that it is not law of tort, but it is a law of torts. So these are the general conditions for imposing tortious liability. That is a wrongful act, which we have seen it in another session, legal damage, in which these two legal maxims, injuria sine damno and damnum sine injuria, these are very important, and the most important element, or we can say the characteristic of a tort, that is awarding legal remedy. These are the references. Thank you.